thank you very much, Professor Peters. Thank you to the Max Planck Institute, Dr. Florian Kreiner, our other co-organizer, for taking up this idea and inviting this really all-star cast of scholars to discuss these important issues. The members of our panel are all quite well known. I'm not going to go through their biographies extensively. I'm sure many of you know them, and if you don't, you can find out more information on their university websites. We are going to start with Professor Sarah Nouwen, who has her permanent home at the University of Cambridge, but is now at the European University. We will then turn to Dr. Asli Olcay from the University of Glasgow, and then have a joint presentation by Professor Ingrid Brunk and Professor Monica Hakimi. Ingrid is at Vanderbilt University Law School, and Monica is at Columbia University, but also here for several months as a visiting scholar. I am very pleased to be able to moderate such a panel of such prominent scholars. Let's start with Sarah.
Good morning, and thank you for the invitation to be here with you. Now, after the very inspiring talks this morning, one may have the inclination to say, let's start drafting. We want to hear what the Ukrainians want, and we start drafting, and we also think, Article 52, Article 53 of the Vienna Conventional Law of Treaties, what's in, what's out, what can we do, what can we not do? Let's get legal, let's get technical. I must disappoint you. I have been asked to say something more generally about peace agreements, problems of potential. And I still hope that that is useful, because when we talk the rest of the day, we may want to think more generally about what has happened with peace agreements elsewhere, and also the whole language of peace agreements, so that when we talk today, we understand in what kind of context we are using the language of peace agreements, and how that differs from how other people may be talking, other people in the same room may be talking about peace agreements, and how we actually can be talking past each other. So what do we talk about when we talk about a peace agreement? In law, we don't have a legal definition of peace agreement. It is not a legal term of art. It's also not a legal category that appears somewhere and that gives effect to all kinds of legal consequences. We have seen treaties that have the title peace treaties that have nothing to do with ending a conflict. Vice versa, we also have instruments that do end armed conflicts that are not called peace agreements. So the name itself may not give us much. Now, I'm going to give a definition, not with a view to saying the rest of the day everybody should follow the definition, but more to say what people are generally talking about and where definitions differ. So the one kind of classic and much used definition is that of a formal agreement between warring parties which addresses a disputed incompatibility, either by settling all or part of it or by clearly outlining a process for how the warring parties plan to regulate the incompatibility. Now, what is the attention here? Formal? Well, formal does not necessarily mean that it has legal status. So there are a lot of formal peace agreements between state and non-state actors that do not have legal status. So formal usually mostly refers to written. Notice too that it's a peace agreement, not necessarily a peace treaty, right? For the same reason. You can have peace agreements with non-state actors. The treaty language is usually reserved to interstate. So this definition covers both interstate and intrastate definitions. What we see included in this definition are process agreements. So you have an agreement about how the peace talks are going to be held. Or partial agreements, for instance, only an agreement on security arrangements or only an agreement on political aspects. But there are also comprehensive peace agreements that have all these aspects in one agreement. All of this is covered by this definition. Not included, because of the emphasis is on addressing the disputed incompatibility, are pure cessations of hostilities armistices and ceasefires. Now, one can have a discussion about it. Some people say actually we should treat a ceasefire as a peace agreement. I'm not going to take a side here. All I'm saying is today, when we're talking, we may want to specify in which way we're talking about a peace agreement. Now, talking about a peace agreement suggests that there are at least two sides. These days, there seems to be a passion for plans. These are usually unilateral, and that's not necessarily an agreement. So for some countries, we've seen a lot of peace plans presented as peace agreements, but there's not a clear sign that the other side has actually accepted those. That said, the language of peace agreements has been used in contexts in which the peace agreement was imposed. So the word agreement then can also be put in square quotes. We talk about Versailles as a peace agreement, but of course Germany was not at the table to negotiate. So I'm not saying we should exclude that from the concept of peace agreements, because practically speaking, these have been peace agreements. What I'm emphasizing is that imposed peace agreements come usually at an enormous price, and we'll get to that price later. But the thing too about this imposed peace is, of course, it has a long tradition. Here, a quote from Tacitus, where he says, they make solitude more in the sense of a desolate place, and they call it peace. This was a criticism of the imperial peace, and we've seen the Pax Romana. Now, that brings us to this idea, and I think that already begins to reflect a bit of the discussion that we had this morning. How can one get peace? One can get peace through victory. Yeah, and I mean, again, there was a reference already to after the Second World War. You can have the victory of one side, and you can have the victory of the other side. So we can be thinking, okay, what about a peace agreement in case Russia wins? What about a peace agreement in case Ukraine wins? And it's interesting that for a long time, talking about a peace agreement was not done with Ukrainians, because a peace agreement implied concessions that they said are, not the right thing to do, incompatible with international law. Peace agreement is not the way to go. We now see a bit of a shift, but if you also read this interesting article by Tatiana Kasilova and Danai Landau, where they talk about Ukrainian visions of peace, it is peace through victory. So in some of the elements that were mentioned this morning, we can also hear this model. There will be a peace agreement, but mostly based on, or in some respects based on the Ukrainian victory. And then there's the concept of a peace agreement based on a peace through negotiations and mediation. And that is usually the case where the military alternatives for ending the war are not feasible or not desirable. And not desirable in the sense of it's costing too many lives. And that is the kind of peace agreement where there are mutual concessions. So when we talk today about a peace agreement, the content will very much depend on which model of how the conflict ends, so how peace is achieved. Now, how do wars end? We do see total victories, and many of those cases we don't have a peace agreement. Of course, Versailles there is an exception. We see conflicts petering out, we have frozen conflicts, and then indeed peace agreements can be ways to end the conflict. Now, there are many examples of interstate conflicts that ended without peace agreements. Germany, post-World War II, managed to do without a peace agreement for a very long time, and then there was an arrangement to settle the situation after or around the reunification. Of course, all of you know much more about that than I do. The Korean War had an armistice, but no peace agreement. The Vietnam War, Iran-Iraq, Iraq-Kuwait settled through a Security Council resolution. And I think the UK and Argentina is interesting that there is no peace agreement, precisely because it is about contested territory. So very often, if territory remains contested, there is no peace agreement. And Tanisha Fazal in her research has observed that there's a clear trend in the post-World War II era to move away from formal peace treaties to conclude interstate war. And it's a very different development for tendency than what has happened with intrastate war. I think the one thing to take away from this is that wars can end without peace agreements. And that doesn't mean that nothing happens. One can do also a lot through unilateral steps. For instance, if we think about the stakes of Berlin after the Second World War, the massive security architecture was a de facto peace protection. So through things other than a peace agreement, one can do things to promote what one wants to have. Now, why then have interstate peace agreements? I think the most important reason is to save the lives that would be lost in the pursuit of a total victory. Every day that the war is allowed to continue, people are dying. It can help to have an official recognition that there was an armed conflict, particularly in situations where one of the parties denies that. And it can allow the normalization of relations. More ambitiously, one can try to address the causes of the conflict and prevent recurrence. I think this morning we already heard references to what is needed for that. Also ambitiously, one can try to sort out the upheaval caused by war. So one can deal with prisoners of war, the massive displacement that has been caused. And then a tricky area, settling on reparations, assigning responsibility, and punishment. Now that is what we heard this morning as one of the key ambitions. When we look at peace agreements, interstate peace agreements in history, we can kind of see an emblem. At the time of the just war theory, this was quite common, precisely because if you have a just war idea, then you also have a just peace idea. The moment that we went more to the idea of legal war and technicalities about it, but no clear prohibition, we see that amnesties are the common thing, and so common. For instance, if you think the Peace of Westphalia, Article 2 of the Peace of Münster, has "there shall be perpetual oblivion." It's the starting point of the whole agreement. This was so customary that even if it wasn't explicitly provided, it was implied. This was a normal customary law. Of course, there's amnesty. Now, of course, then we move again to the charter area where the use of force is prohibited. And yet, we don't see very much in interstate peace agreements this idea of assigning responsibility and imposing punishment. And we may get back to this, why this is the case. I would say that the Versailles Peace Agreement, where it's so clearly on assigning responsibility, imposing punishment, and of course we know that the Kaiser was eventually not persecuted, but the reparations were almost punitive reparations. It's an exception, and maybe for good reasons, because it didn't go particularly well. So this is something I think to keep in mind also for the for moving forward here. Now, the last few decades has not been a decade of interstate peace agreements, but of intrastate peace agreements. And there have been a lot of studies about them. What can we learn from them about durability, substance, impact? And one may say, well, we don't even have to look at that because the lessons are not transposable. Intrastate is very different from interstate. And of course, yes, at first sight, that's absolutely the case. The key thing, and which is also the question that brings us together in the conference description, is that in interstate conflict, we very often have as the starting point a violation of Article 2.4 of the UN Charter. And that raises this wholly difficult question which was put to us: how do you draft a peace agreement when the conflict itself shatters foundational legal norms? That said, and that raises these questions: is the agreement void? Can it legalize the consequences of illegal activity? And also, can the agreement include amnesties for the crime of aggression and other international crimes? So these are the kind of questions that come from that, and the questions that I'm not going to answer because I would be stealing the thunder for the rest of the 2 days. My point is that, and one other dimension that we can ask to address is the short term versus the long term. You can have a short term fix, but what are the consequences of that for the long term? Does it undermine the chances for the long term? My point is that actually at closer inspection, there are a lot of parallels between these intrastate and interstate conflicts. True, in international law, there's no prohibition on non-state armed groups to take up arms against the government. So we don't have an Article 2.4 in the context of intrastate conflicts. However, many intrastate conflicts begin or are fueled by fundamental violations of human rights, which are also international law, right? Think about the Syrian conflict. And if you then get afterwards, for instance, a power sharing agreement, is that agreement then also legalizing those violations? Secondly, when non-state actors take up arms against the government, think about Colombia, Sudan, they may not be violating international law, but surely they're violating fundamental norms of the domestic legal order. And what is international law's reaction to those violations? Article 6.5 and additional Protocol 2 give the widest possible amnesty. So international law encourages, in a way, a legalization of the most fundamental violations of the domestic legal order. And this happens also in the Minsk II agreement that was concluded with respect to the Ukraine conflict. And then all these tensions that we're talking about, peace versus justice, the peace versus justice also in the context of power sharing, they were the heart of the tensions of intrastate conflicts. So in that sense, they're not new now. Now let's look at the issues addressed in these peace agreements, and they may look different and for good reasons. So for intrastate conflicts, the key question is how to regain the monopoly on the use of force. In other words, how do you get the non-state actor to disarm? In interstate conflicts, it's the security arrangements with the external actor. Intrastate, a lot of attention for power sharing, internal self-determination, and quite often transitional justice. Interstate, it's about external self-determination, and not having these violations of your territorial sovereignty. Possibly interstate reparations, but the individual access to those reparations are rare. That's usually done interstate. And for a long time, amnesty was explicit, as I mentioned, explicit or implied. So there was, in a way, negative transitional justice. There is no accountability. The rationales are, of course, evident that in interstate conflicts, there's this idea that the one side can withdraw behind its borders. It doesn't have to live with the other side. In intrastate, one wants to regain the monopoly on the use of force. That means that one group needs to disarm, which creates fundamental existential questions. However, it has been argued that in the context of Ukraine, actually, it resembles the intrastate dilemma precisely because Russia doesn't want to respect those borders. So it is similarly existential. Now then say something about the legal status of these agreements. In intrastate agreements, as Asli's work has beautifully illustrated, they usually don't have legal status because it's with a non-state actor, and that's quite difficult. And my own book, which develops that point, on empirical points, has shown that that's usually the case because for the parties, the agreement is too important to be law. They don't want to hand over the agreement to the lawyers. They want to keep control over the implementation. Now, in the interstate conflict, the presumption is that because we're talking about two states who have, or more states that have the capacity to conclude treaties, the presumption is that international actors act on the international plane through international law and that therefore the agreement has legal status. It's interesting, though, that the Minsk agreements were intentionally drafted in a way not to have international legal status. The Russians wanted it to have international legal status because it would mean recognition of the non-state actors on the international plane. The Ukrainians resisted it in all possible ways. It's also notable that there are many interstate peace agreements that have not been registered in the UN treaty series, precisely to suggest it is not a legal document, but it's a political document. Now, that has pros and cons. Of course, as lawyers, we think, oh, it's much better if you have law because you can go to the court. But let's be realistic. I mean, how often will a peace agreement be enforced in court? And if so, how effective is that? So we may need to think, is it in some circumstances better, actually, to have a non-legal agreement. For instance, all the issues about Article 52 and 53 of the PCLT may be far less relevant. It is also an idea, perhaps, to think about addressing issues in separate agreements, some of which may have legal status, others not. So any status of void pursuant to Article 52 or 53 will then not affect all these other issues. And finally, one thing that one can think about is many things can be solved or done through unilateral actions. So in a way that both sides do them at the same time. For the reasons, I'll briefly say one separation that's often made in peace negotiations or peace mediation is, do you focus on the text or do you focus on the process? And I would argue that the process school is mostly important for the intrastate conflict because it's about living together. It's slightly less important perhaps for the interstate, where it's more about the importance of the text. At the same time, in both situations, for trust building, it's really important for being able to meet face to face. And that, of course, can be difficult with arrest warrants being on the table. Finally, let me say one thing about the difference between negotiated and mediated. So what we have seen in empirical research is that if agreements are directly negotiated or with a mediator who's more of a facilitator, so allowing the talks rather than doing all of the action, you see much more self-enforcement than if you have a very interventionist mediator, especially, let alone, if you have a coercive mediator. In the case of a coercive mediator, the implementation of the peace agreement will continue to depend on coercion. That means my time's up. So the final point on this is one of the most dangerous scenarios that we've seen is if international actors promise a level of enforcement that then they cannot keep up with. This is part of the explanation of the Rwandan genocide, where the Rwandan genocide followed a peace agreement. Good. I think I'll stop here because of time.
Thank you very much, Sarah. We are doing a transition, and our next speaker is Dr. Olcay from University of Glasgow.
Thank you so much, Greg, for the kind introduction and also for the kind invitation to be part of this discussion. Thanks to you all for being here. Like Sarah, I'll start with the same caveat that I'll offer some general reflections on the practice of peace treaties since the end of the Second World War and international law's relevance to this practice. I won't offer in-depth legal discussion of these points because that's going to be done later today and tomorrow, and it's not going to be that much tailored to the Russia-Ukraine context. I'll start with a brief overview of the practice, then reflect on the relevance of international law to this practice and some of the legal tensions that we see in the field of peacemaking in relation to the form and negotiation process of agreements, but also in relation to their contents. I'll end by offering some thoughts on some of the peacemaking techniques that have been used in this practice to navigate legal tensions. Some of this just builds on Sarah's points about definitional issues. When we look at the practice of peace treaties in the context of interstate armed conflicts, there isn't as much as what we find in relation to intrastate armed conflicts. If we adopt a broad approach to what a peace instrument is and include ceasefire agreements, unilateral declarations, non-binding instruments, Security Council resolutions, we find about 150 instruments from this period that relate to interstate conflicts. A recent data set from last year finds 55 treaties that match the VCLT definition of what a treaty would be under international law. And even this includes ceasefire agreements, some partial peace agreements, and also interstate or mixed agreements concluded in some of the so-called multi-level conflicts like Cambodia, Bosnia, and the DRC. If we narrow our definition even further and look at interstate treaties that address purely interstate conflicts in a comprehensive way, I think we only see 6 or 7 in this period. So the pool of practice is limited. And this is rightly attributable to the decline of interstate conflicts in this period, but also to the use of interstate peace treaties, as Sarah mentioned, to end such conflicts. There are lessons to be learned from this practice, but I just wanted to flag at the start how limited this practice is, especially on some of the legal issues that we are interested in today. So how do we understand international law's relevance to this practice, especially given that there is no body of law in international law dedicated to peacemaking? The relevance of international law is generally shaped by two key factors, I think. The international political environment and what we understand at a given time in terms of what peace requires, what peacemaking looks like, has an impact on our understanding of the relevance of international law. What do I mean? To give an example, there are various rules in international law that require accountability for conflict-related crimes or human rights violations, but there is nothing in international law that says that these issues should be addressed in a peace treaty. This has just become a contemporary normative expectation that's not necessarily based in law. So this political environment affects our understanding of international law's relevance. And obviously the context, the specific context is the second factor. Which specific issues arise in a specific peace process, peace negotiation, and which rules of international law those issues implicate also guide us in our understanding of the relevance of international law. So as a result, we have diverse rules of international law that are relevant to a peace agreement's form and negotiation process, and also an agreement's contents. I haven't tried to be exhaustive here. I've just tried to chart some areas of overlap between international law and peacemaking, and tried to identify some legal tensions that I've highlighted in red. In terms of form and negotiation process, obviously, we go to the VCLT, which provides generic guidance about treaty making, which is not tailored to the peacemaking context. Probably what the articles that are most relevant to this context are 46 and 52, although I've never come across a discussion invocation of Article 46, where a manifest violation of a fundamentally important rule of internal law is concerned in the context of peace treaties. But this might be relevant to Ukraine given the significant issues of constitutional law that the negotiations lead to, give rise to. Article 52 obviously has been discussed a lot, and I won't go into too much detail here, but I just wanted to point to, again, how limited the relevant practice is, and if anything, how it points to the limited use of Article 52. So this recent data set that I mentioned earlier finds only 3 peace agreements since the end of the Second Cold War that have provided a basis for de jure territorial exchanges that may have benefited a party that's used force unlawfully. And only in one of those cases, the use of force was unequivocally unlawful, and that's the 1990 agreement between Iran and Iraq pursuant to a Security Council resolution. There are 2 others where the use of force may have been unlawful, and the wrongdoer state benefited from territorial exchanges. There are some other agreements that don't necessarily involve territorial concessions, but have been challenged on the basis of Article 52 in literature mainly. So the Moscow Protocol from 1968, the Luanda Agreement, the Lusaka Ceasefire Agreement from the DRC Uganda context, Dayton Agreement, the agreement signed by the Federal Republic of Yugoslavia in 98 and 99 around the conflict in Kosovo. These have all been challenged in literature, but never in practice. They have remained in force despite coercion claims. To go back, we also have some legal tensions also arise outside of the law of treaties. International criminal law is one example, and it's relevant to Russia-Ukraine because of the existence of arrest warrants. And we have seen arrest warrants complicating peace talks in other contexts, in Bosnia, in Uganda, in Sudan. The existence of an arrest warrant does not in and of itself obviously outlaw negotiations with those individuals, but they do create practical challenges. For instance, talks may need to be relocated to territories of states that are not parties to the Rome Statute, or in some cases, because of this normative pressure, contact with those individuals may be limited, may be indirect, and may be limited to essential contact. but negotiations do take place despite arrest warrants, and agreements are concluded in those situations. So it's not a legal red line. In terms of content, again, I'm not trying to be exhaustive here, but I've identified some areas of legal tension. Again, if we go back to the VCLT, Article 53 is relevant here. If a peace treaty conflicts with a peremptory norm of international law, it would be invalid. In practice, again, we don't see many examples of this. And I know that territorial concessions will be discussed later on. So I wanted to give a different example about self-determination, which is accepted generally as a peremptory norm of international law and is implicated in many of the intrastate but also interstate peace agreements. So an argument was built on the principle of self-determination in relation to the Oslo Accords, for instance. The ICC prosecutor argued that the accords, to the extent that they violate the right to self-determination of Palestinian people, would not be determinative for the court. This line of reasoning was also taken up by Judge Tiladi in his declaration in the ICJ's advisory opinion on the legality of the occupation, where he also reminded that the accords would be invalid to the extent that they violate the principle of self-determination. A similar argument was developed again by the court in the Chagos advisory opinion in relation to the 1965 Lancaster House Agreement. Not a peace treaty in traditional sense, but an agreement that's aimed to resolve a political dispute that has territorial dimensions. And here too, the court argued that there is no international agreement in this case because of essentially what are conditions of duress. So these conditions, if they can't be articulated through Article 52, can still be articulated through 53 in terms of their impact on the validity of a peace treaty. And this might also be, again, relevant to Ukraine in terms of highlighting that an externally imposed peace treaty in which Ukraine has had no meaningful role would be probably against the principle of self-determination. Beyond the law of treaties, again, what might be relevant to this context is the law of occupation. Because a future peace treaty between Russia and Ukraine may deal with the situation in the occupied territories if the territorial dispute is not resolved otherwise. And the law of occupation states that agreements between occupied and occupying powers can't derogate from protections under this body of law. If we accept that IHL norms, including these norms, are of peremptory status, this would also lead to invalidity, and the same argument has also been raised in relation to the Oslo Accords by the ICC's prosecutor. Beyond rules that would lead to invalidity, there's obviously the potential of clash with various norms of international law that are not peremptory. And we can't be exhaustive here. This would depend on which rules are implicated in a particular peace process. And often these would be rules around accountability, duties to prosecute, duties to make reparations, and none of these are of peremptory status. Violating these would lead to state responsibility, but not necessarily to invalidity, treaty invalidity. So these are some of the legal tensions that arise in this body of practice, that we see in this body of practice. So how do peacemakers deal with these legal tensions? What techniques do they use? The seemingly most straightforward solution is to comply with international law. But what that looks like depends on how we understand what international law says. On almost every issue of international law, there are diverse views. If we go back to the example of Colombia, the 2016 peace agreement that Sarah also mentioned, many argued that the transitional justice chapter of that agreement did not align with international law, whereas many others argued that it did. So there were different views on that, but the agreement worked in practice. And I think today it's largely accepted that that arrangement did indeed comply with international law. But compliance with international law will obviously look different to different parties. and there may be interpretive scope within various international rules to accommodate creative compliance arrangements. Even in relation to Article 52, I know that authors, even in this room, have put forward different interpretations that would, some of which would allow territorial concessions in Russia, Ukraine, and some of which would not. Another technique is avoidance, not dealing with a thorny issue. And Dr. Karnevich this morning mentioned that they might prefer not addressing the issue of accountability in a peace treaty. As I said earlier, nothing in international law requires this. And this is an available technique to peacemakers. In some cases, avoidance may also be in the sense of not bringing up issues of invalidity or illegality. As I've said, there are various agreements that have been challenged in the literature in terms of the coercive background, but not in practice. So parties may also adopt an arrangement that violates international law, but this is simply not brought up in practice. Sometimes issues that are avoided could be referred to international dispute settlement. So again, Dr. Karnevich this morning mentioned issues of reparations and claims commissions. There is precedent for that. For example, in the peace agreement between Eritrea and Ethiopia, a boundary commission was set up to deal with the territorial dispute that the parties couldn't resolve, and a claims commission was set up to deal with issues of reparations and claims in that area. Ambiguity and working misunderstandings. These are also in the toolbox of peacemakers. Whether they work depends on the political context. Again, this ambiguity can relate to different aspects. For instance, it can relate to the legal status of an instrument. Again, we can go back to the Minsk agreements example. Were they legally binding? Was Russia a party to it, or was it only a mediator? These were the ambiguities that the negotiators and the mediators worked with. The amnesty provision in the Minsk agreement is another example. One party argued that it didn't cover international crimes. The other party argued that it did, and this was always obvious in the negotiations. The Security Council endorsed this agreement, and during the debate, this was brought up, the issue of amnesty, and it was still endorsed. So again, these are ambiguities that parties, relevant actors worked with. In the case of the Minsk agreements, it didn't work. Again, whether these work depends on political context. We can also look at the Colombian example again. The parties there, because it was an intrastate agreement that didn't have international legal status, tried to attach international legal status to the agreement because they wanted to protect it from domestic legal challenges. So they came up with different arguments that the agreement is a special agreement under IHL and that's why it has international legal status, etc. Eventually, this legal strategy didn't work and the agreement did end up before the Colombian Constitutional Court. But it did work in the sense that it brought the parties to the point of signing an agreement, thinking that their agreement would be protected by international law. So these misunderstandings, ambiguities can work sometimes. Temporary or de facto arrangements are also among the peacemaking techniques used. These would look different depending on the issue addressed. Professor Weller has a paper on territorial arrangements that can be adopted in this Russia-Ukraine context, where parties can refrain from putting in place a de jure arrangement that would infringe on international law through some temporary or de facto arrangements that work around the legal issues. I won't go into the detail of this, but there are other examples of such temporary arrangements. If you look at the Egyptian-Israeli General Armistice Agreement, there a without prejudice clause was included because the parties couldn't agree on one political issue around Palestine. So these arrangements can also be used in the context of political disputes, not just necessarily territorial disputes. The Simla Agreement on Jammu and Kashmir establishes a de facto line of control. It doesn't resolve the dispute over sovereignty over the contested territories. The Lusaka ceasefire agreement is a ceasefire agreement. It established a de facto system for that. And the ICJ has confirmed in the armed activities case that it doesn't necessarily say anything about the legality of Ugandan military presence. And in this case, the use of force was unlawful. The court had found that. But again, the validity of the agreement was not contested, and the de facto arrangements remained in place. A final example from the agreement between Cameroon and Nigeria in relation to the Bakassi Peninsula, which was also addressed by the ICJ. And here, even though Nigeria's use of force was again unlawful, it was given certain rights in the disputed territory for a temporary period of time until Cameroon took back the territory. So there are various temporary arrangements, de facto arrangements that can be used to work around legal tensions. And finally, there's the option of going to Security Council. And again, I won't say too much about it because there's another presentation today addressing this topic. There is a debate around to what extent the Security Council can cure defects, legal defects in a peace treaty. And there are, again, different views on this. I just wanted to, again, flag a few examples from practice where the Security Council endorsed an agreement that could have been challenged under Article 52, or that could potentially plausibly be said to have violated the principle of self-determination. So we find not necessarily agreement, but peace instruments, let's say. So we have examples from the context of Bosnia, from, again, the Kosovo conflict. The Security Council endorsed these agreements that were signed by Yugoslavia, and most recently the Gaza peace plan, obviously. So even though there are, again, legal debates around the power of the authority of the Security Council to act in this way, these also stick in practice sometimes. Overall, there are all these techniques available, but whether they can be used depends on legal viability in a specific context, but also on how internationalized and legalized the process is and whether there are courts involved in the process. So we will discuss some of these issues later today in the context of Ukraine, Russia, and I'll end on that one for now.
Thank you so much, Asli. And finally, Professor Ingrid Brunk and Professor Monica Hakimi.
Okay, good morning, everyone. So, when Russia launched its full-scale invasion into Ukraine in 2022, Professor Brunk and I were editors-in-chief of the American Journal of International Law. We still are, and we said we should have a agora on this topic. And in our introduction to the agora, she and I argued that, or really asserted that, Russia's 2022 invasion of Ukraine represented one of the most, if not the most significant shocks to the international legal and political order as it had existed since the end of World War II. And we got a lot of pushback for that argument, actually. A lot of people said to us in response, oh, you are US-centric or Eurocentric scholars who are focusing on Ukraine because of your own biases, and you don't realize that there have been other incidents, especially incidents that have violated Article 2.4. Don't forget Iraq 2003. And those incidents were also seriously shocking to the global order. And we think that this is not necessarily any different. And in fact, if you go back to that period, you might remember that there were lots of arguments circulating by people who purported to represent the views of the global South, even though they often came from places in the global North, saying these are, again, hegemonic views to take so seriously the Ukraine piece. And so that got us to think seriously about why it is our intuitions were that this case is uniquely significant. And it came down to us to the point that this case is about, as other ones were not, the annexation of territory and the violation of what we've since argued is really one of the most foundational, if not the most foundational norms of the post-World War II system. And that is not actually Article 2.4, but rather, or not only Article 2.4 of the UN Charter, but the prohibition of annexations as a distinct norm. And what is distinct about the prohibition of annexations is that it goes specifically to the transfer of title to territory, sovereign title to territory. And so what we did in our piece that further elaborated on why this norm is distinct, why it is significant and uniquely significant is we trace the historical pedigree of the prohibition of annexations. And we showed actually that the prohibition of annexations is a prohibition that is intricately connected not just to the prohibition of the use of force across natural borders, although it is connected to that norm, but to three distinct projects that together we think have helped to define the essence of the post-World War II and especially the post-colonization period, or the period following the massive wave of decolonization of the 1950s and 1960s. And those three projects are, first, the project to establish states as territorially defined entities with authority within those territories. We refer to this in our piece as a project on territorial entrenchment, because what it is, and it's a project that, of course, predates the UN Charter by at least 100 years, and it's a project to try to tie public authority, state authority, to particular territories. Now, before the prohibition of annexations came into being, there was still this effort to tie state authority to territory, but state authority was much more contingent, because if territory can very easily change hands through the use of force, then it's harder to entrench a single state's authority in that physical space. And so this was again, centuries-long project to try to link the two together and make it so that state authority could be more salient and sticky, and not so easily transformed or disrupted. The second is the one to which Asli was addressing, which is the interest in principle of self-determination. This is basically an emancipatory principle. Its roots also predate World War II. And although many attach it to European peace movements and self-determination movements, it has also been an animating force in Latin America. And it was a transnationally pushed norm to say people have a right to self-determination. And then, as you know, as many know, what counts as self-determination and how to define the right to self-determination has long itself been contested. But at or close to the core of this idea is the right to be free from external domination. And the third, and there are questions, of course, about how to understand this right to be freed from external domination in conjunction with this project on statehood, on the desire to establish state authority and entrench it in particular territorial units. Because you might say, and people do say, that the statehood project, the territorial entrenchment project, pushes against the self-determination of some of the people in those spaces. So the emancipatory project for self-determination overlaps with, but is not exactly the same as the statehood one. And the third project is the one with which I think most contemporary international lawyers now conjoin the prohibition of annexations, and that's the prohibition on the use of force across territorial borders, which of course became solidified with the UN Charter. But before we got to the UN Charter, I want to underscore the significance of the prohibition of annexations to all three of these projects, and also to underscore the point that for states in Latin America, which of course were newly emergent states, the prohibition of annexations was integrally connected to their efforts to establish themselves as secure, independent states in defined territories and to provide for their self-determination in relation to more militarily powerful states. So the self-determination and the territorial entrenchment projects with which the prohibition of annexations is connected are projects that were specifically pushed from these Latin American states, which are now, in more contemporary parlance, put in the category of the global South. We want to use that phrase, despite all its problems and the extent to which different states of the global South actually vary considerably. And it was militarily powerful states that were much more invested in connecting the prohibition of annexations to a broader collective security structure, and in particular, the prohibition of the use of force. So when you get Article 2.4 of the UN Charter at the end of World War II, that provision actually says nothing about the transfer of title to sovereign territory. That language does not appear in Article 2.4 at all. And if one looks at the debates after Article 2.4, one can see that actually the question of whether or in what circumstances annexations of territory, forcible acquisitions of sovereign title to territory, were still permissible was an open question. Because, of course, Article 2.4 does not prohibit the use of force across the board. Article 2.4 prohibits certain uses of force, when I say aggressive uses of force, and then it permits uses of force with Security Council authorization, as it's been interpreted, and in self-defense. And so the outstanding question at the end of World War II was, well, are annexations of territory done pursuant to a defensive operation, or perhaps an operation conducted with the Security Council's endorsement, lawful? Is that permissible? And it was through actually the massive wave of decolonization of the 50s and 60s, and again, strongly with the voices of states from which we now refer to as the Global South, that said, no, we need actually to treat this prohibition as distinct. And that sort of came together. The prohibition of annexations came together as a distinct norm and as an absolute prohibition, really in the Declaration of Friendly Relations from 1970. It was at that point that we got an articulation of the prohibition of annexations as both itself a norm and as absolute. And we think that this is actually the best way to understand the prohibition of annexations as a distinct norm that is related to several other norms and not just the prohibition of the use of force. So it's related to a whole set of norms that are designed to stabilize territorial and then over time maritime borders, and to provide for states to exercise authority within those borders. It continues to be related to the norm on self-determination. Now, again, the specific content of the norm on self-determination is open to debate and contestation, but I think most would agree that the coercive taking of territory without the participation of the people involved and that form of external domination of people does violate the right to self-determination. And then finally, it is integral to Article 2.4 of the UN Charter, which of course many take to be the foundational norm of the post-World War II legal and political system. And that's because the thirst for territory has often been a motivating incentive for the use of force. So once you take the right to take sovereign title off the table, and you no longer make sovereign title the sort of prize of aggressive war, then you're also reducing the incentive for that war. And so these two are very intricately connected, but they're not exactly the same. And why is it that we think it's really important to underscore the fact that the prohibition of annexations does overlap with Article 2.4, but is not exactly the same? And that's because if it is at risk, as we think it is in Ukraine, and this will be my hand over to Ingrid, if it is at risk in Ukraine, it means that all three of these projects, and not just the prohibition on the use of force, is at risk, and not just in Ukraine, but also in other parts around the world. So it's a good handoff.
Yeah, perfect. Thank you, Monica. So I want to briefly address some of the implications of our argument with particular reference to the war in Ukraine and the possibilities of a peace deal, potentially even one with territorial concessions, even though we've heard that formally that's off the table. for the moment. And I'll look ahead on the kind of the bridge to the next panel. So I'll look ahead at some of the issues that are going to come up in the next session. So our argument obviously highlights the specific importance of the prohibition of annexations in limiting conflict over territory, but also to ensuring self-determination. I think there are many signs that the prohibition of annexations itself is eroding right now at this time, as distinct from the prohibition on the use of force in the Charter. These include the decline in U.S. security architecture. This is beyond just the conduct of the United States that itself explicitly undercuts the norm, such as the territorial threats to Denmark, but also the unpredictable words and actions of the U.S. government, with, for example, respect to NATO. These are loosening the implicit and explicit security guarantees from the United States that we think helped, for better or worse, keep the post-World War II territorial order intact, despite the erosion of Article 2.4. Consider also the past attempted annexations that led to stalemates or frozen conflicts that are slowly now being resolved in favor of the annexing country. Golan Heights and the Western Sahara serve as very important examples here, in which Israel and Morocco's positions are gaining very significant political and even legal backing. I would point out the UN Security Council resolution on the Western Sahara in 2025, as well as much more explicit and open threats of annexation, including, sadly, from my own government, but we could also put here more explicit language around West Bank and otherwise, specifically in terms of annexations. So we think the norm is at risk. And we also think it's politically important to see these links between Ukraine, Western Sahara, Palestinians, occupied Palestinian territory. And again, this is a different way of conceiving of the set of issues that belong in buckets rather than just putting all of these conflicts together with Iran and Iraq in Article 2.4. All right, so how to think about a peace treaty in Ukraine. Much of the focus has been on whether a peace treaty would be void, either because it was procured through the threat or use of force. And here, and this is where annexations might fit, it might be void because it violates a peremptory norm. Both are provided for in the Vienna Convention on Law of Treaties. Greg Fox, thank you so much for convening and inviting us. And now I'll disagree with you. But only because he disagreed with us, not seriously. Greg Fox questions in this context whether the distinction between annexations and use of force is a distinction that makes a difference. Well, we think that it does. As a purely formal legal matter, title to territory, as Monica has suggested, is simply a different thing than the use of force. A coercive annexation of territory is wrongful, not only if or because it is the result of an unlawful use of force. Peaceful annexations in which the use of force is lawful are also unlawful. The use of force in self-defense is lawful. It cannot lead to the annexation of territory, right? And this is where you can see the two norms becoming decoupled. Why does it matter here? One might try to take an otherwise invalid peace treaty and cure it in various ways by the UN Security Council, as Asli mentioned, as we'll have a presentation later, as Anna Peters and Florian Kriener have argued. Thank you so much for inviting us. I'm now going to disagree with you. A ceasefire might be negotiated and then endorsed by the UN Security Council. So we have the Lukasa ceasefire agreement as an example, and the UN Security Council endorsement or implementation might solve this problem about it otherwise being procured pursuant to the use of force. But it doesn't really solve the territorial problem. Kriener and Peters say that we can't have territorial concessions, right? This is the distinction with Lukasa, because they would undermine 2.4 by rewarding the aggressor. that reasoning is not convincing. Any peace deal might give and take and might reward the aggressor. That's not what makes territory different here. Territorial concessions are not unlawful just because they result from or reward an unlawful use of force. They are unlawful even if they follow from the lawful use of force, and this makes it much harder to cure a territorial annexation question through a UN Security Council resolution than it is to cure the problem with the use of force. I have some other examples, but we can get into that in the conversation in the next panel on Security Council and uses of force. But I just want to say, even in purely doctrinal terms, we think this matters, to use Asli's term, to try to come up with creative compliance with international law for any peace deal that's produced. It may be more difficult to do that if the deal involves territorial concessions than if it does not involve territorial concessions. All right, but let's move in a little bit different direction. And another way that territorial annexations might matter for peace, ultimate peace deal. And this goes to self-determination, as both Monica discussed and Asli discussed. Thinking in those terms about self-determination, I think helps bring into focus some of the current problems on the ground in Ukraine. And I'm happy to be corrected here by people who know more about the actual war as it's unfolding, but I'm relying on human rights reports from the UN and from the European Union that highlight an ongoing and increased pressure on Ukrainian people in occupied territories to adopt Russian passports, to accept Russian legal status. We see deportations, forcible transfers of Ukrainians, including, of course, children. We see the nationalization of abandoned property in occupied territory, providing the basis of potentially for the redistribution of property. We can see these as sort of systematic population exchanges, making it difficult for Ukrainians to return, I got it, 2 minutes, I'm on it, to facilitate Russian recruitment into the military. This is very similar playbook, Georgia, Crimea, and other regions of Ukraine. These emphasize the connections between the turnover of territory and the lives and self-determination of the people who live in that space. If an ultimate peace deal involves territorial concessions, and I have no view on whether it should or should not, or whether it will or will not, I'm just suggesting if it should, there are ways we might try to structure that deal. Elections are complicated. Exercising the right of option for people to be able to move wherever they want, trying to find ways to push back against the Russification, even of territories that are currently belong to Ukraine, were they to become part of another sovereign. I just want to expand the set of issues that we're talking in this space to include these which have not yet very much been on the table. And then finally, Sarah mentioned the work of Randall Lassafer, who's a historian on peace treaties. One of the things that he notes is peace treaties, folks, they're all about territory, right? The Peace of Westphalia is just a massive territorial settlement. Yeah, it's got some other language that we always cite, but what does it really do? It settles conflict over territory. If we're looking for a long-term durable solution in Ukraine, we're going to need to figure out a way, and this in a way is the most difficult question. This is almost more difficult than trying Putin for a crime of aggression, right? How do we find ways to reduce the conflict over territory that is likely to remain in these areas, no matter whether there are territorial concessions in the end or not? So with that, I'll conclude.